Hello and welcome to Legal Briefs. This is attorney Jeremy Hogan and we are today talking about the SEC versus Ripple case because this is Hell Week, as I call it, and there was a lot of stuff filed so far this week, but most exciting, of course, we get to see parts of the big Hinman Deposition, and all of that stuff that was filed. There was some good, some bad, and just some ugly. And we're going to tell you what is what and which is which, and then we're going to speculate on the outcomes of these hearings. And yes, we are going to talk about the Hinman deposition. It appears to have been a very interesting deposition. We only got snippets of it, but I snuck a camera into the room so we can see some of the behind the scenes action, and here it is.
Oh! You pig! You want to get me killed! When'd you unload it?
Last night. You see, in this world, there's two kinds of people, my friend. Those with loaded guns, and those who dig. You dig.
The legal lesson to be learned from Mr. Eastwood: never be a lawyer at the deposition or at the trial with the unloaded gun. Now, I'm not feeling great today and I'm actually heading to the doctor right after this video, but kids, listen to me, half of life is just showing up. So I threw on the jacket and here I am, fever and all, just for you. So before I pass out, let's get to it and let us start with the SEC's motion to obtain Ripple's Slack messaging communications. And on August 16, we got Ripple's reply brief, so now we know how it will defend itself. And here it is right in the first paragraph. Quote, "The SEC's extraordinary demand calls for an extensive and costly fishing expedition that would likely take months to complete and come at very significant cost. The SEC's disproportionate request is also unreasonably duplicative of Ripple's extensive production of over 1 million pages of discovery, including emails, documents, text messages, and responsive Slack messages for 33 custodians," close quote. So the SEC is trying to find internal Ripple communications that show that it was treating XRP more like a security than a commodity. And Ripple's response would fall under the good, as far as the good and the bad and the ugly, which is our theme, because it's good because the law on this issue is one of proportionality. In other words, the request has to make sense in terms of what it might show in relation to the burden on producing it. So if you've already produced Slack messages from the top 33 people at Ripple, why do you also have to search the receptionists and the interns' Slack messages? It's costly and you're not going to find anything new or relevant anyway. So that's the good. Now to the ugly. Look at Roman numeral 2 in Ripple's response. Quote, "Although Ripple's collection of Slack data was significant, Ripple's e-discovery vendor inadvertently failed to collect Slack DMs and MPIMs." Ouch. Now that's not good. And now Ripple has to backpedal and explain why their discovery company didn't search the direct messages. And well, it's like trying to explain a text message from an unknown woman on your cell phone. There's never really a good answer, even if you're innocent. So in our good, bad, and ugly theme, that goes in the bad category. Which is a shame because our judge, Judge Netburn, has already ruled on a similar issue involving Slack messages back in 2013, and she was pretty conservative in what she required the party to produce. The name of the case was In Re Morgan Stanley Pass-Through Certificates. It was some kind of foreclosure case. And here is what she said. Quote, "Accordingly, plaintiffs have not made a sufficient showing that the burden of review, including the burden of reviewing false search hits," close quote. So she's going to want to see something from the SEC about why they need these additional people at Ripple's messages searched. But the mess up by Ripple's e-discovery vendors gives the SEC a bit of a wedge in there. So I predict that the judge will grant the SEC's motion in part, or at least keep that option open to compel further production, depending on what Ripple finds and produces. Okay, moving on then to Ripple's motion, which is honestly much more interesting and juicy. And here is where we could see some sparks fly if there were going to be sparks in this case. Recall that all the way back on April 6th, there was a hearing with Judge Netburn, and she told the SEC at that hearing to produce certain internal documents related to XRP, Ether, and Bitcoin, and related to Mr. Hinman's infamous Ethereum speech. Now that hearing was on April 6th, and this is still going on. And sticking with our theme, is this good, bad, or ugly? I'd say it's definitely ugly, because after that hearing in April, she was actually forced to clarify her ruling, and here's the clarification. First, produce communications with third parties. That's number one. and also produce official interagency memoranda rate Bitcoin, Ether, XRP. That's number 3. And that's it. It's really not that complicated, yet up to recently, the SEC had failed to produce any documents, and that was based on the official deliberative privilege. So let's take a look at what the SEC is saying here in its reply brief. Quote, "The court should not override that privilege and punish frank governmental deliberations, particularly where the internal pre-decisional deliberative material defendants seek, which they never saw or knew about, is not relevant to any claim or defense." Now, on the good side here, the SEC reply brief is really well written. On the bad side, it's like deja vu reading this thing, because I feel like this issue has been argued about 3 times already, and each time Judge Netburn has ruled the exact same thing, and that's the type of thing that tends to piss off judges, and I think the SEC realized that in preparing for the brief, and so look at what they hid in the footnotes. We are looking here at footnote 3, quote, "In the document review process in connection with this motion, the SEC determined to no longer assert DPP over parts or all of approximately 40 previously withheld documents." Aha! The old backtrack just before the hearing trick. No, I've done it before, and it can take the sting out of an upset judge. So the SEC has decided to unprivilege some of the documents at the last minute. But bottom line, and a prediction on this motion, there is not enough time left in discovery, and this has just dragged on too long. I think Judge Netburn is going to have to take some of these documents in chambers and do an in-camera review, which just means just by herself. So she's going to do an in-camera review of some of them, and some judges won't do that, but I don't see how she can avoid that at this point in time. And then I think she will order some of those documents produced after she looks at them. Hopefully we'll see a very specific order. But really, all of this motion practice pales in comparison to what was attached to the SEC reply brief, which were the parts of Hinman Deposition. And there was some juicy stuff in there. These excerpts of the deposition were of course chosen by the SEC, so we don't see all the bad stuff for them yet. But this is our first look at some real evidence in the case, and it didn't disappoint. So we only have about 90 pages of the deposition out of probably over 500 pages. I mean, it was apparently an 11-hour deposition, and much of what we do have is redacted. But let's start off with a trap laid by the SEC, obviously together with Hinman, and here it is on page 95 of the transcript. Question: do you recall other issues that were brought to you and members of your staff about the application of the federal securities laws to digital asset transactions in which they sought guidance without seeking a no-action letter? Answer: yes. Frankly, the one I recall the most clearly is probably the one when XRP came in with a person who had my position before me, as well as enforcement counsel. They were interested in, is there a way to restructure what we're doing to bring it within compliance of the securities laws? And the first thing I said to them was, you're continuing to offer XRP without any kind of restrictions that would apply as a securities offering. If you want to come into compliance, you have to stop doing that, and they understood that, close quote. So this is what I call a trap response, and the SEC had obviously discussed this with Mr. Hinman ahead of time to make sure to get his response into the testimony somewhere. So there's no doubt whose side Mr. Hinman is on here. He has a remarkable memory on this interaction out of the hundreds of interactions he probably had, which is amazing. Now the answer is in the good category for the SEC, because obviously the SEC's position on the fair notice defense is that Ripple knew it was breaking the law, and by Mr. Hinman telling them that, they should have known. But maybe not as good as the SEC would hope, because later on in the deposition Mr. Hinman is asked when his meetings with Ripple took place, and he says this. On page 376 of the deposition transcript, quote, "I think some of these meetings began in 2018 and some early meetings with XRP representatives, general meetings, and then meetings trying to figure out how XRP could come into compliance were later, probably 2020, close quote. So keep in mind that the SEC investigation of Ripple began, I think, in 2019, and the lawsuit was December of 2020. So according to his testimony, Mr. Hinman met with Ripple generally in 2018, maybe 2019, but the meeting in his trap testimony was in 2020. So it was only in 2020 that he met with Ripple and said, I think you are breaking the law. But also keep in mind that when asked what they could do to come into compliance, it seems according to his testimony, his only response was to say, stop selling XRP. And then a couple of months later, the lawsuit was filed and served on Ripple. So in other words, this is how a company in a burgeoning industry was treated. They were only told to stop realizing its main source of income while the SEC tees up its lawsuit against them. Not very helpful or very nice if you ask me. That's just my opinion. In any case, the testimony only really helps the SEC for the period from when Hinman told the SEC in 2020 until the lawsuit was filed. It does nothing for the fair notice defense pre-2020. And there was another bombshell in the deposition which the SEC wasn't so happy to highlight, and that has to do with the SEC's policies for SEC employees owning securities. And there is a policy which basically says that the SEC employees can't own securities they are in any way working with. So if they're about to purchase any security, the SEC employee has to be pre-cleared. And here's how that line of questioning with Mr. Hinman went. Answer: if you buy securities, you're supposed to get them pre-cleared. Question: and am I correct that digital assets were not covered by the securities clearance form until 2018? Well, Mr. Hinman waffled answering that question, but of course the answer is no. The SEC did not consider digital asset securities for their ethics purposes until 2018. And I know that because you never ask a question on Cross you don't know the answer to already, and you can kind of tell that they already have the document that shows that. So that bodes very well for Ripple as far as its fair notice defense for the periods from 2013 to 2018. And there were a couple of other interesting interactions in that deposition, but to be honest, I've run out of steam, and that's all I've got for you today. The good, the bad, the ugly. I made it without passing out. Thanks for watching.